Where were you last week?
I'm gonna get a fill up here. Home, but I didn't, because I had called the preliminary hearing, whatever.
Correct.
And they said that you guys rescheduled the time, and I thought it was the date. But so many rescheduled, and I had talked to the corner lawyer, and they said that I didn't qualify. So after the Zoom meeting, I knew I had court on the 7th, but I didn't know, because after I had called to check in with the lady who I was supposed to call to check in with, she said that I was supposed to have court, but I forgot. I didn't know what day she said. She just said it was at 2:00.
So you still don't qualify, is what they're telling you?
Yes.
You appealed the denial? Are you working?
I'm self-employed.
Oh, you must be making some major money, buddy.
Not really.
Got a nice Jordan on.
Kind of slow. It's kind of slow.
Well, you have to provide them with information about your income. You provided that?
Yes.
Okay, and even with that provision, they denied you court-appointed counsel?
Yes, but it's always been the same. It's whatever I ever. So if I was approved to show up, have an attorney in the first place, I don't know what's the difference now.
That is true, because you were originally approved, correct?
Right.
You're gonna need to appeal the denial then. Okay, and then provide update information, especially if you can show that it's been slow.
Yes.
So that means your income has changed, okay? So you can contact the public defender's office and find out how you appeal that denial and provide further information, and we'll give you a new date. I'm gonna quash your bench warrant because you do typically appear. We're gonna reset his probable cause conference.
You want it on a day you're here, can another judge do it?
I'll do it.
Can do the July 27th at 9.
July 27th at 9 a.m., okay?
Yes.
You have a second, get you the notice to appear, and then you should get in contact with the public defender immediately to find out how to appeal it, okay, sir? Thank you. I put quash in there, right?
I think that's
The soup?
and Darling.
Who won't start his audio? Reset him in person. And we still don't have a public defender here? Why not?
So Darling,
Yes, Mr. Darling will reset him. Mr. Mitchell, we had to remand him because Mr. Mitchell doesn't come to court. Can I have a new date for Mr. Mitchell? Mr. Mitchell, we're resetting you to July 17th. At what time?
1:30.
At 1:30.
At 1:30. So I don't get a bond or anything?
No, you're remanded. You want to know why you're remanded?
Please.
Huh?
Yes, can you tell me, please?
Yes, it's because you continuously fail to appear to court.
Well, that was, okay.
And we don't want to continue tracking you down since 2020. We want to move on.
I have a good reason.
Okay. Well, when the attorney gets here, we'll have them get in contact with you so that we can see how we're going to proceed on the violation. So we can't do that because the public defender did not appear. They were supposed to be here at 1:30. You requested public defense to represent you, correct?
Yes, ma'am.
Yeah, they were supposed to be here at 1:30. No one's appeared. And I'm in the middle of a jury trial, so I can't wait for 30 minutes for them to get here. So So we'll see you next week, sir.
Okay.
Sean Taylor. I recognize you.
Yes, ma'am. I'm sorry. I don't know. Can you hear me?
I can hear you. Can you hear me?
Yes, ma'am. I'm so sorry. I was trying
Sean Taylor.
to. I had to call the court and get the Zoom ID meeting. I mean, the county clerk and get the ID meeting. I'm sorry, man.
Let's see. On the record in the matter of the people of the state of Michigan versus Sean Taylor, file number 22-02521. Mr. Taylor, today's the date and the time that's set for a probation violation arraignment. I have here request and summons for probation violation. It states that you allegedly violated the terms of your probation by failing to provide proof of drug testing at the on-site in Ferndale. So you have the right to have a contested hearing. You have the right to be represented by counsel. If you're found to be in violation of the terms of your probation status can be revoked and you can be sentenced to a term of jail time. Do you understand that?
Yes, Judge, I understand.
Okay, your probation could also be extended, or you can have some additional sanctions imposed, including but not limited to scram, tether, or additional sanctions such as testing increase. Do you understand that?
Yes, Your Honor.
Did you want an attorney to represent you for this violation?
No, I'm okay. I'll just ask to talk to you real quick once I get a chance, because it's really kind of my fault, but at the same time, I just want to let you know what happened, because it's not really even the jam reporting thing. I was supposed to, because I don't know what they got going on, but I was really supposed to get my probation officer this it's like what is it? A medical marijuana form. He said I could buy it online, but I got a back problem already. I told you when I first met you first time, and I got to get an MRI, and I was going to get the medical marijuana form from him, but my doctor.
Okay, but what is that? I'm not really 100% sure what that has to do with you setting up the testing that you're supposed to be doing. But I'm going to stop you because let me just stop you though, because today's not the date for the hearing. It's just an arraignment, so I don't want you to say anything that could be used against you if you wanted to proceed to a hearing, okay? So if you want to unmute yourself, you're saying you do not want an attorney, you want to proceed to a hearing and you want to explain yourself at the hearing?
So do I need an attorney? Because I never really did this before.
Well,
ain't that going to make me have to pay?
It doesn't hurt to have some advice. I personally wouldn't go to court without the advice of someone who's trained legally, but that's up to you.
I take the, but I'm going to have to pay for the attorney, right?
Well, did you have a public defender in the underlying matter?
Yes.
Okay, well then you would likely qualify for a public defender in this as well.
Oh, okay.
And the public defender is typically here for the arraignment. I'm not sure where our public defender is today.
Can I just ask a quick question?
Not guilty. I'm going to enter a plea of not guilty at this time, and I am going to note that you're requesting court-appointed counsel. We'll set it for hearing. What's your question, sir?
All right, so because I was supposed to be off probation last month, so does this mean it's going to get extended or
I don't know. We have to see.
Yes, ma'am. Okay, well, so you about to give me a different court date right now?
Yeah, it's going to be the hearing date. That'll be your date to explain what's going on if that's what you choose to do, or require the prosecution to prove that you violated your probation.
July 24th.
Okay.
July 24th at 1:30 will be the hearing, okay? You can appear via Zoom.
Thank you, ma'am. You have a great day.
Same to you. Okay. What's your name, sir?
Dan Darling.
On the record in the matter, the people of the state of Michigan versus Dan Darling, file number 22-02645. FY. Mr. Darling, today is the date set for an arraignment on a probation violation. I have here a request in summons for a probation violation. It alleges that you failed the terms of your probation by A, failing to report since April 12th, 2023. It alleges that you failed to make any payments. And then it also alleges that you failed to complete the 10 hours of community service ordered by the court. And then it alleges that you failed to enroll in random testing and that you failed to enroll in the economic crime class. And so each of these would be violations of your probation status. If you are found to be guilty of those violations, sir, you could be sentenced to a term of jail time. Your probation could be extended, or you could have additional sanctions or oversight imposed. You have the right to have an attorney represent you for these violations, and you have the right to have a court-appointed counsel represent you. Did you want to request court-appointed counsel at this time?
Yes, Your Honor.
Okay, we'll enter a plea of not guilty at this time, and we'll set it for hearing.
July 24th, I don't think.
You need to appear in person. You understand that?
Yes, ma'am.
Okay, July 24th at 1:30 in person at the court. It will be your hearing. I've noted that you are requesting court-appointed counsel, okay?
Okay, thank you, Your Honor.
Thank you. We'll see you on the 24th.
All right, thank you.
Okay, no one else can agree for me, Inspector?
Jordan, you and Mitchell.
Give Mr. Mitchell a new court date. Yeah, we don't have a public defender here anyway. Nothing I can do. It even takes place. Mr. Darlings. Okay. And then, once that's done, we can bring the jury back. Okay, we're back on the record in the matter of the people of the state of Michigan versus Angel Robinson. The jury is back in the jury box. We have some procedural instructions here on the screen. So if you could fix your attention there. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If the jury could please rise. And raise your right hand. Do each of you solemnly swear or affirm in this case now before the court that you will justly decide the question submitted to you, and that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instruction of the court? If you do so, please say I do.
I do.
Thank you. You can have a seat. You will have a written copy of my instructions, but you won't get them until the conclusion of the proofs today. So you won't be able to refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of trial. At the close of trial, I will provide you with a copy of my final instructions for you to use during your deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. The defendant is charged with the crime of malicious destruction of personal property. To prove this charge, the prosecutor must prove beyond a reasonable doubt the following elements. First, that the property belonged to someone else. Second, that the defendant destroyed or damaged that property. Third, the defendant did this knowing that it was wrong, without just cause or excuse, and with the intent to damage or destroy the property. Fourth, that the extent of the damage was less than $200. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about November 5th, 2022 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an open statement, but if he makes an opening statement after the prosecution makes theirs, or he can wait until after. These statements are not evidence. They're only meant to help you understand how each side views the evidence. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, though, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job is deciding what the facts of this case are, is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. You should wait to ask your question until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to my court officer who will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand. It should say immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to my court officer as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you are, if you wish, able to discuss this case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. Number one, it is your duty as the juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. Number two, this means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers or on television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using your cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all the evidence and my instructions, we will consider lots to decide which one of you will be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. That concludes my procedural instructions, and you can proceed with your opening statement.
Thank you, Your Honor. Good afternoon, everyone. Thank you for bearing with us. My name is Jeff Brodowitz. As was said earlier, I don't know if any of you remembered it, but I represent in this case the people of the state of Michigan. And why we're here today, as I'm sure you've heard quite a few times now, is that the defendant Ms. Robinson, has been charged with the crime of malicious destruction of property. Now, as the judge just said, malicious destruction of property contains 4 elements. 1, that the property belonged to someone else, that there was damage done to that property, that the defendant had the intent to damage that property, and that there was some, at least in this case, some amount of damage up to $200. In this case, the people expect that the evidence will show that here, the property in question was a pickup truck. That pickup truck belonged to the victim in this case, Mr. Haywood Greenwood. People expect that the evidence will show that there was an altercation between Mr. Greenwood and Ms. Robinson in a parking lot late one night, and that during that altercation, Ms. Robinson did, with intent, damage that pickup truck of Mr. Greenwood. And that damage obviously was some amount less than $200. I would urge you, as the jury, to pay attention, to focus on those elements that you have been instructed in that charge, and when I believe you will find that at the end of testimony, the verdict you will come back with is guilty. Thank you.
Thank you, Your Honor. Your Honor, may I stand on this side just like that?
Oh, absolutely.
Thank you. Good afternoon again, everybody. Hope you had a good lunch. Again, my name is Joseph, and I represent Ms. Robinson on this. Today, Ms. Robinson sits here wrongfully accused of malicious destruction of property. As you heard earlier, one of the elements was the intentional destruction of property. Today, you're going to hear testimony that the destruction was not intentional. and there was an altercation that happened before that that caused the damage to the property, but it was not intentional. And so though there are 4 elements, meaning you have to put a checkbox next to each one and able to find her guilty beyond a reasonable doubt. The number 3 is the intent. Number 3 is the intent, and that is the one that I'm submitting that during the course of this trial, you will find that there was no intent to create that malicious destruction of property. The people's case is built upon one person's testimony, one person's version of events, and no other witnesses in this matter. We plan to show that this person, their credibility is at play here, and that is why you should not believe this person's testimony, and you should believe that Ms. Robinson did not have the intent to destroy that property. And during the course of this, you're going to learn that the complaining witness in this matter was actually the aggressor in the incident. The complaining witness was the one who actually initiated the incident that led to today where we're at. I urge you to listen to what is there and what is not there. Take into consideration the evidence that's been presented, the testimony, as well as what has not been presented. What did not fill in the gaps to provide you with beyond a reasonable doubt. I look at it as the people's burden is to kind of fill a glass, right? So they're filling the glass or they're filling a bucket and with dirt. Until it goes beyond a reasonable doubt, that bucket is reasonable doubt. It has to overflow that to go beyond a reasonable doubt. So take today's testimony, and there's going to be some testimony for the defense, some testimony that's for the people. But at the end of this, you will find that there was not enough reasonable doubt to fill that bucket, to overflow that bucket. So the state of Missouri is called the show me state. So there's a saying, so show me, right? So in 1899, a U.S. congressman said on the floor, frothy eloquence neither convinces nor satisfies me. I'm from Missouri. You have got to show me. And that is their job. Their job is to show you. Like I stated earlier, I really don't have to do anything by law. I won't do that, but I will. But it's their job. They have to show you. They have to show you beyond a reasonable doubt that Ms. Robinson had the malicious intent to create this damage. Again, I remind you that the burden of proof in a criminal trial is beyond a reasonable doubt, which is the highest burden in our legal system, not just our criminal system. It is the gold standard. It is the gold star, and it should be the hardest to get to. And I want to state it in a different way. So beyond a reasonable doubt is to provide proof to the exclusion of all reasonable doubt. So it'd be 2 different ways to kind of look at that. So the people have to exclude all reasonable doubt from your mind. They have to exclude, like, okay, well, maybe this is reasonable, this is reasonable, this is reasonable. Their presentation has to remove all of that. Okay. Now, not unreasonable or beyond a shadow of a doubt. That's not what we're talking about. Reasonable doubt. We talked about that earlier during what is. So that is a people's burden. And again, through the proofs and through the trial today, I would submit that the 3rd element will not be met in this. Ms. Robinson is innocent of the crime that she's been charged with. She was not the aggressor, as you will find throughout this trial. And I would ask that at the end of this trial, you come back with a verdict of not guilty for Ms. Robinson. Thank you.
Prosecution can call their first witness.
Thank you, Your Honor. The people would call Mr. Haywood Greenwood.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Okay, you can have a seat there. There's a microphone that's in front of you, and the lady behind you is my court recorder. She has to take down everything being stated here in the courtroom. So all of your responses need to be clear. They need to be loud and audible, okay?
Yes.
Okay, because we can't write down head nods, head shakes, and ahas accurately into the record. If you don't understand or hear a question, you can ask to have it repeated. If there is an objection by either of the attorneys, you would stop speaking immediately. I'll make a ruling on that objection, and I'll tell you if you can give that answer or not, okay?
Yes.
Please state your first and last name, spell both of them.
Haywood Greenwood, Haywood. Last name Greenwood.
Please proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Greenwood.
Afternoon.
Mr. Greenwood, do you know an individual by the name of Angel Robinson?
Yes, I do.
And how do you know Ms. Robinson?
Previous dating, at one point considered a friend.
And how long did you date Ms. Robinson?
Yeah, probably within a 5-year span, so probably like a year and a half to probably about a year. I really can't. It was like sporadic thing.
And when did that relationship end?
I like 2016, 2015, somewhere in here.
All right. So I'm going to take you back here, Mr. Greenwood, to the date of November 5th, 2022. Do you remember that date?
Yes, I do.
And where were you on that date?
I was at where we're at. I was in the parking lot of the Lansing Center, waiting to find a parking spot across from the Nut House. So like, never been down to the Lansing Center. It's like at nighttime, it's like lively. So they have like that. Lansing Center has their parking lot and it's open to the public, but most of the time, like if you're trying to find a parking spot, avoid parking lot behind Omar or something, you'll go in the parking lot, make a U-turn, and you're coming in and out of it. So I was like at the very end of the parking lot, waiting for somebody to come out to find a parking spot there.
Okay. And so is that location is in the city of Lansing?
Yes.
And it's in Ingham County?
Yes.
Okay. So when you were in that parking lot waiting for a parking spot, did you encounter Ms. Robinson?
Yes.
What happened that night?
Well, I was sitting in my truck. Like, once again, like the Nut House is like right across the street. So I was sitting over the parking lot. So she came out, she was walking with a guy named Courtroom or whatever. She saw my vehicle and she kind of parted ways from him and walked towards my vehicle and flopped herself on the hood of my truck. So then she came around to the window where I had the window down. Like I never was out of my truck. I was still sitting in my truck. My window was like halfway down because my windows were all tinted. So it was like a conversation between, just like talking to the window. And at the time I was pretty much, when I saw her, I was kind of disgusted with her because I was trying to tell her like, you're doing all this, going to bars and stuff while you were already in trouble. I was trying to, just pretty much give her counseling about the stuff, and she didn't like the words that I was saying to her.
Okay, so you're having this conversation with her through the window. What happens next?
After I was pretty harsh with words, and I'm not gonna lie about that. I was cussing, like telling her, like, it's kind of effed up, and that's all you do is use people, et cetera, et cetera. And she didn't like what I was saying, so then she tried to spit. Oh, I know, I take that back. She tried to punch me first through the window. And I reached out and I had her at arm's length. So when she did that, I pushed her out off of my truck and she ended up falling back. So she got back up and she decided she wanted to start kicking the side of the panel of my truck. So at that time, I got out my truck and pushed her away from my truck again. She kept coming back towards the truck. Where at this time, she couldn't do any damage right there. So then she took herself around the back of my truck.
Okay. Hold on, just hold on right there. So after she You said she kicks the side of your truck, you get out.
Yeah. My driver door.
Are you in between her and the truck at this point?
Yes.
Okay. And is she still trying to get at your truck?
Yes.
Okay. So then what does Miss Robinson do after that?
She ends up going around to the back of the truck first. And I'm like following behind her, trying to get in between. So she takes her phone and she bam, bam, like my tail light, and busts my tail light out. So once again, I end up pushing her back off my truck because I'm trying to protect my truck. So she gets up, she runs to the driver door, the passenger door, on my passenger door, and on my F-150, you can't open the door. She was trying to get in my truck. So you can't open the door unless I unlock the door itself on the passenger side. Or the driver's side is unlocked. So when she couldn't do that, she took the phone again and broke out my passenger mirror.
Okay, so after she breaks out your passenger mirror with the phone, what happens?
After she did that, she just kept trying to come at me, trying to fight me or whatever. And like I said, I got pretty much long reach. So I'm like pretty much holding her at bay while she's sitting there swinging away. So I push her one final time away from me again, and she falls on the ground. And I stop and I said, I literally stuck my hand out, was like, are you done? To help her up. I helped her up, and she ended up running off that way. And I think her purse, the guy, Courtney or whatever, had set her purse on my hood on my hood of my car. And I took the purse off the hood and just threw it out in the street. And at that time, then I pulled off. And because usually on Michigan Avenue at that time of night, there's like police everywhere. So like during this whole thing, no police ever came. So after the final push, she went off. She ended up going down the corner, and I went down straight to the police department to flag down a police officer because I was upset about the whole ordeal about my truck and so forth.
And so when you headed down, you said you flagged down a police officer. Did you make contact with that officer?
Yes, he was literally correct. He was getting ready to, he was getting ready. He said he was getting ready to come down that way anyway. And so I ended up telling him, and he ended up stopping me because at the time I didn't know my face was bleeding. I had scratches on my face from trying to defend her off from tearing my truck up and trying to keep her at bay. And from there, I ended up talking to the police officer. He said he would write a report. And from that point on, I think that following Monday, I went down and gave the same report to the probation officer that she was under.
Objection, Your Honor. Yeah. Move to strike the last sentence about probation officer.
On the basis of?
May we approach, Your Honor?
You may. Okay.
Your Honor, the objection is to move to strike the last one or two sentences due to relevance.
Okay, any response to the objection?
No, Your Honor, the people would, we can move on.
Thank you. That the last sentence is stricken. That's not to be considered as evidence. You can consider it.
So you said when you met with the police officer, he mentioned that you were bleeding. Were you ever during this altercation, did Miss Robinson ever make contact with you? Physically?
Physically, she was just wailing away. So like I said, I literally was just like, I wasn't trying to fight or anything like that. I just wanted to get away from the situation. So I was like literally holding her back. It's like equivalent to like putting your palm on a kid's head and they're just, going like that. So I didn't even know that I was, strapped until the police officer brought it to my attention.
Okay. And do you recall where roughly you were bleeding from, where you were scratched?
My face, and I still have permanent marks on my face.
All right. Permission to approach, Your Honor?
You may.
Okay, I am going to show you what has been marked as People's Proposed Exhibit 1. If you could just take a look at that, and do you recognize that photo?
Yes, I do.
And how do you recognize it?
The police officer took down in front of the police station, right in front of the police station.
And is that a fair and accurate representation of how your face looked that night?
Yes.
All right, at this time, people would move for admission of People's Proposed Exhibit 1.
Any objections to exhibit 1?
May I quickly, one here, Your Honor?
You may.
Mr. Haywood, do you know if that image has been edited in any fashion?
No, I have the same pictures in my phone.
Okay, so did you take those pictures or did the officer take them?
No, the officer took these pictures, but I can open my phone and show you the pictures that I took at home.
But just to be clear, that photo has not been edited to your knowledge.
No, there's a capital right there in the picture.
No objection, Your Honor.
Okay,
All right.
People's Exhibit 1 is admitted.
And can you please describe for the jury what is in that photo there? I guess it's already been kind of described, but
Pretty much me with scratches on my face from the night that all this took place.
all right. And then that night as well, did the was there ever any documentation made of the damage to your vehicle?
Yes, the police officer took pictures.
Okay. Did you ever document that yourself as well?
I took pictures. I have the pictures from the very next morning, like 9:36 on my phone, that I took daylight pictures versus the night pictures.
Permission to approach again, Your Honor?
You may.
I am handing you what has been marked People's Proposed Exhibits 2 through 4. There should be 6 photographs there. If you could just take a look at those really quickly.
People's 2 through 4 are 6 photos.
Yes, there's 6 photos. There's 2 in each pack. And do you recognize those photos?
Yes, I do.
All right, and how do you recognize them?
There's the damage done to my F-150.
All right, and are those a fair and accurate representation of the damage that was done to the truck?
Very much so.
All right, at this time,
Yes.
people would move for admission of People's Exhibits 2, 3, and 4.
Any objections to 2, 3, and 4?
No objection, Your Honor.
People's 2, 3, and 4 are admitted.
So if I can direct your attention to People's Exhibit 2 there. I believe that should be if you could describe for the jury what is that top picture there, and what that is.
Show them or?
I will publish them to the jury afterwards.
You
If you could
can-
just describe, or
You can hold it in a form that they can at least see it, so they can know what you're describing.
Well, this is my driver's door right here. And from her kicking the door, it was dented in on this one. Then see like where her footprints were, like trying to kick the door in on the driver's side.
and then you mentioned just to clarify for the jury. So one of those pictures is at night, and one of those is the daylight. Is that correct?
Now, actually, both of these
Or sorry, both of those
Both
are.
of these
My
are
apologies.
night
Um,
pictures. I have
yeah,
day
but if you
pictures
could-
in my phone.
Scratch that. If you could look at People's Exhibit 3 then, and again, describe for the jury what is in that picture there.
This is a night picture of my mirror, and then this is a day picture. I think I had to go back on some site and do the evidence thing or whatever. So this is once again with a picture. This is the one that the police officer took, and then this is the one that I took. And well, I guess you said I didn't say it, but that's the other evidence that the window was broken.
Okay, and then if you could look at the final exhibit there again and describe for the jury what is in those pictures.
This is my back tail light that she bust out with the phone going around the truck. And this is, once again, this is the day picture that I took to submit to evidence as well.
Alright.
So this is the one that the police officer took that night. And then this is a picture that I took for my,
Permission to approach again, Your Honor.
You may.
And permission to publish People's 1 through 4 to the jury.
Yes.
So just very briefly, Mr. Greenwood, so you said that, do you see Angel Robinson anywhere here in the courtroom today?
Yes, I do.
And can you indicate for the jury where she's sitting and an article of clothing she's wearing?
She looks like a black hoodie on, right next to her lawyer.
Please may the record reflect that the witness has identified the defendant.
Any objection to identification?
No objection, Your Honor.
Identification is noted.
This time, no further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon. My name is Joseph. I represent Ms. Robinson. If you need me to slow down or rephrase something, please let me know. Okay. All right. So let's go back to that day in November. Had you already entered into any of those bars at all?
No, I literally had just got there to meet with some of my cousins that were down there.
Okay. And did you have any drinks with you inside of the vehicle?
I had no drinks.
Okay. So you never threw a drink at Ms. Robinson then?
I do. Wait, I take that back. I'm sorry. After when she ended up breaking apart for me, I had a 32-ounce volume dairy drink. And after she made the last attempt to spit on it when she was running away, I threw my drink.
Let me rephrase the question. Did you have a drink with you in the vehicle?
I had a 32-ounce mellow yellow.
Okay. And did you throw that at her?
Yes, I did.
All right, thank you.
Thereafter the fact
Thank you.
of all this at the very end.
And so, isn't it true that you asked Ms. Robinson to approach your vehicle?
No, I didn't. She came directly to my vehicle out of the bar because she saw me.
Hold on, sir. Is it true? Did she or did she not? Did you or did you not call her over? Yes or no?
No.
All right, thank you. Did you grab her while you were in your vehicle, or was the physical altercation while you were outside the vehicle?
I put my arm out when she tried to punch me, and I held her at bay when she was trying to punch through the window.
All right. Was your door open at all at that?
My door was closed.
All right.
I didn't get out of the door. I didn't open my door until after when I pushed her away when she tried to spit on me. I pushed her away and she fell back off of my running board.
Okay.
And then
hold on, sir. So let's go back a little bit earlier with your testimony. You had said that you had said some pretty harsh words to her. Is that correct?
Pretty much.
And
yes.
you were cussing at her. Is that correct?
I wouldn't say as in
You had said,
like anger, but I was telling her it was like a friend looking out for somebody that you care about.
And when was the last time you saw her prior to that incident?
When she was broke and she needed $60 to get her phone turned on.
Time frame, month, week, year?
Probably about 3 days.
3 days? Okay.
Yeah.
All right. And earlier you said you were disgusted with her. Is that correct?
The behavior, knowing that the trouble that she was in at the time.
Is that what you stated? That
Would
you
you
said
like?
you were?
Would you like me to?
I'm asking
answer
if you said you were disgusted with her.
I'm going to
Yes or
answer the
no?
question to.
It's a yes or no
how it
question.
is.
It's yes or no?
Yes, I was.
All right. And did you give a statement to the police that day?
Yes, I gave him a statement exactly of what happened.
All right. And do you remember explaining to the officer that she had gotten caught?
That's the look that she had on her face when she came to the truck.
Okay.
She
so
approached my truck. I didn't
Okay.
approach her. I never got out of the truck. So
were you guys in a relationship at that time?
no, not at all.
Okay. Were you trying to rekindle that relationship
Not
at
at
that
all.
time? So you've never sent her text messages trying to rekindle the relationship?
There's nothing to rekindle. Anything that I ever talked to her was uplifting, trying to keep her out of trouble. Let's say, helped her out numerous times. I felt sorry because she was downward spiral.
All right. Hold on, sir. So were you intoxicated that day at all?
Not at all.
All right. And when you said that you guys were together in 2015, 16, that's about when the last time you guys were together?
Probably about then, yeah.
All right.
I can't put exact date or year. It's been so long. I've had
Are
a
you,
couple surgeries from cancer,
So
so
are you-
I don't know.
are you still jealous of her?
Not at all.
All right.
I wish nothing but the best
It's
for her.
a yes or no question, sir. Yep. How tall are you?
6'2",
All right. And about how much do you weigh?
225 to be
Right.
exact.
Thank you. So isn't it true that you grabbed her while you were inside of your truck? Is that correct?
It's not true the way that you're stating
Okay,
it.
so you're sitting in your truck, is that correct?
Correct.
And it's a F-150, correct?
Yes.
It's a pretty big, pretty much full-size pickup truck, correct?
Yes. She was standing on my running board.
Okay, all right, so you grabbed her and while you were sitting in your car, is that correct?
I grabbed her when she.
Yes or no, yes or no
When she
question?
made the attempt to punch me, I
Okay.
grabbed her
You
to hold
grabbed
her
her.
at bay. Yes,
You grabbed her, okay?
yes.
And when you grabbed her, did you injure her when you grabbed her at that moment?
How would I know if I injured her if I was trying
It's a
to?
yes or no question. Do you know, did you injure her at that moment?
No, I don't think I did injure
Okay, all right.
her. I just did enough to deflect her trying to punch.
Your
and spit
testimony
out.
earlier was that you just kind of held her out kind of like a child to make sure that she wasn't flailing.
That testimony was after we were outside of the truck.
So let's move to outside of the truck.
Okay.
All right. Did you injure her at any moment at that point? Do you recall?
No, other than pushing her back. That's it. That's
Okay.
all I ever did.
All
I
right.
never
So,
slapped. I never punched. I never did anything to her. I kept her at bay.
okay, so your testimony was you were just deflecting and defending, is that
Just,
correct?
that's all.
All right. Earlier, you had stated that you were discussing with her, but she was using people. Do you feel like she used you?
I feel like I was,
It's a yes or no question.
yes, I will say that.
You feel like
Yes,
she used you?
yes.
And then earlier, your testimony was that she circles the vehicle and starts busting out your mirror and your tail light. Is that correct?
Yes.
All right. Were there other witnesses that saw this?
Sir, there was so many people out there that did nothing. I actually, you're,
So this is my question. Are you aware of any other witnesses that saw this incident?
I couldn't say, I wasn't paying attention. My main purpose was trying to keep my truck from being destroyed.
Okay. Were any of those, any of that damage to your truck? The mirror, the tail light, was that all old damage? Or are you saying that was from?
Brand new. I have pictures prior in my phone, days before that. That was a brand new truck, $20,000 truck that I had just bought. I hadn't even put a scratch on it myself.
So brand new as in?
Off the lot, 20,000, used, however you want
Okay,
to
so
say it.
it was a used car. Is that
Yeah,
correct?
without a scratch on it. I
Okay.
have plenty of pictures of that truck.
But just to be clear, it wasn't a brand new off the lot truck. It was a used
It was
off the lot truck that was new to you.
a used mint condition Ford F-150 that had no scratches whatsoever on it.
And did you provide that to the people at all about the original condition of your vehicle?
What people is that?
The people, you provide picture, those original pictures, if you're saying your truck was in mint condition.
I can
Have you-
provide them now if you like. I
My-
can pull
my
my
question is,
phone out and
have-
show you day by day.
Have you in the past provided those to the people,
Which people?
to the prosecutor?
I'm just dealing with the prosecutor. I've just been showing up for my hearings. That's it. This is literally our first time
Okay.
coming together, other than me showing up for hearing after hearing that you guys kept adjourning.
Hold on, sir, so do you use this truck for any work purposes or anything
Not
like
at
that?
all. I won't move a couch. I won't,
All right.
nothing at all.
All right.
To me, that's like my truck is like a Maybach,
Hold on, sir.
or to me.
How do you know Mr. Courtney Melvin?
Her ex.
Okay, and
I think her ex or
when
her
you
playboy or however
when you
say
saw
it.
her with him, did that make you jealous?
Not at all.
Okay, is that what you meant by you said getting caught, that she was caught with somebody else?
Well, first she approached me, so
I
she
have
was
to answer-
walking.
so-
To me, it felt like she was. I'll just be honest with you. When she came out and saw me sitting in my truck, and she was.
Okay,
I
hold on,
think
sir,
she was
hold on,
in-
sir. The question is.
Can I finish the question?
The question.
You have to answer the question, sir.
It's a yes or no question.
No.
Okay, so that's not what you meant when you said she got caught, that she was caught with somebody else. That's
No.
not what you meant by that.
No.
Okay, thank you. Did you receive any medical attention for your injuries?
No, I didn't. I didn't go to the hospital or anything like that. Like I said, I didn't even know that I was scratched up like that until the police officer brought it to my attention.
So, to clarify one point also, you had said that she didn't have a purse with her, is that correct?
Yes,
And that somebody had put it on the hood of your car, correct?
Courtney said it on the boat. May I answer, because in this melee that was
Okay,
going
hold
on.
hold on.
Can I answer the
No,
question?
it's a yes or
Go
no
on,
question.
hear it.
My questions are yes or no questions, all right?
Okay.
Courtney placed that purse onto the car, is that correct?
Yeah, on my hood.
So she did not have the purse with her at that time, correct?
No,
All right.
she had
You're
a phone.
saying that she had her phone. Can you describe her phone?
Which one was it? Because I've helped her replace like 2 or 3 of them.
Okay, so.
Because she didn't have a
So
phone.
can you describe the phone that she had that day, yes or no?
It was a Metro PCS, or not, is it Metro? A Metro phone, probably about this big, that long. I couldn't tell you, that was back in November, so I couldn't tell you. She probably had 30 phones since
Okay,
then.
so you were close enough to see that the actual phone in her hand?
I actually seen her homing and bam, bam on my truck with it. Yes.
No further questions, Your Honor.
Redirect.
Just very briefly, right? So just to go back over the timeline here a little bit, Mr. Greenwood. So you're sitting in the parking lot and you see Miss Robinson come through. Did you see where she came from at that time?
She just came across the street from the nut house and she was walking with the Courtney.
Okay.
But then she separated off from them and came to my vehicle.
All right, and then the defense attorney asked you about possibly throwing a drink on Miss Robinson. Where in the timeline did that fit?
After I had pulled out of the lot and was headed to the police officer, to the police station, I threw my drink out the window. Yes, I did. I mean, like I said, I wouldn't lie about it. But I was extremely ticked off about my truck. Like I said, I work hard for my stuff, and I haven't even put a scratch on my truck.
Okay, and then again, the defense attorney kept, what do you mean? I guess, what did you mean when you told the officer that she got quote caught?
To me, when she came out of there, like that night, I hadn't really even talked to her, or had any discussion with her, seen her or anything. And it's like, you know how you help the person and help a person and help a person, and they feed you lies. And I don't deal with that person. But I'm sitting in my truck, and then you just happen to walk and see me, and you split off and walk to me trying to explain yourself. There's nothing to explain. I mean, you lied to me. I mean, you just lied about everything.
Okay. One second. All right, just to think a couple more questions. So you're fairly familiar with Ms. Robinson, correct?
Yes.
Okay. From your estimation and your experience with her, would you say she was intoxicated that night?
Very much so.
Objection, Your Honor. Foundation is this an expert witness on intoxication? I'm wondering where this line of questioning is going.
It sounds like a cause for speculation, so
I would.
do you want to respond to the objection?
Yes, Your Honor. The witness here has personal experience with the defendant. I was just asking in his experience in dealing with the defendant if that's how she appeared when she was intoxicated based on their prior history.
That wasn't exactly the question.
Your Honor, I've just renewed my objection for speculation, Your Honor.
I can rephrase, Your Honor.
So you want to rephrase it?
Okay.
May I please stand for 1 second?
Can you do what?
May I please stand for 1 second?
You need to stand up.
Yeah,
Yep.
I told you I had
Yep, no, you
certain
can do-
days.
you can stand up.
For a second. I'm listening.
Just gotta stretch his leg out. That is a tight jury box. Okay.
Again, almost done. So let me see if I can rephrase. So based on your personal history and your personal experience, with Ms. Robinson, was the way she was acting that night consistent with how she would have acted when she was intoxicated based on your history?
She was civil-minded for a second, but then once the words that I used towards her, it was like the angry drunk kicked in.
Oh.
So it's like.
Again, objection, Your Honor, I'm not sure the question was answered.
And at this time, Your Honor,
Mr. Strong, question?
yeah, no further questions at this time.
Okay, thank you. Did the jury have any questions for this witness? Someone from the jury with a question? Okay. Thank you. You can be excused from the jury stand, sir.
Okay. Sit outside for the remainder.
It's up to you. I don't remember anyone making a sequestration order, so you can say it if you want.
Okay.
Okay. Call your next witness.
People have no other witnesses, Your Honor. People rest at this time.
Any other proofs from the people at this?
No, Your Honor, if I may retrieve my exhibits from the jury box.
Okay. And why do you need those exhibits and not the jury?
I can leave them with it.
Yeah, they're gonna need them for deliberation, so that's fine. Or if the prosecution may end up using them, I mean, the defense may end up using them in their case. Are you calling witnesses today?
Yes, Your Honor.
Okay, you can call your first witness.
The defense calls up our first witness, Mr. Courtney Melvin.
You can, sir, if you just raise your right hand for me.
Yes, ma'am.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat there, sir. Okay, there's a microphone that's in front of you and my court recorder is right behind you. She has to take down everything being stated here today. So when the questions are posed to you, your responses must be verbal. They can't be mm-hms and ahs or head nods and head shakes because we can't write that in. So we need yes or no, okay?
Yes, ma'am.
Okay, and then also if you can keep your voice loud and clear, and then if there's an objection, you would stop responding and I'll make a ruling on that objection and then you can give the response if I say that the response is acceptable, okay?
Yes, ma'am.
Okay, state your first name and your last name and spell them both.
Courtney Melvin, Courtney, Melvin, Melvin.
Okay, give me just a minute. Does the jury need any air or is it, you need to circulate this fan or turn that fan on? Okay, sounds good. You can proceed, counsel.
Thank you. Thank you, Ron. Courtney, I want to take you back to November 5th, November 6th. Do you remember that night?
Yes.
All right. Can you tell me where you were at that night?
The Nut House.
Okay, and what were you doing there?
This is having dinner.
Okay, and who were you with?
Angel Robinson.
Okay. Was there anything significant that happened after you're done with dinner?
Yes. As we were leaving, we were walking to the parking lot because I had to park in the Lansing Center parking lot because it didn't have. I have a handicap sticker that parking spaces were unavailable at the Nut House, so I had to park across the street. As we were walking towards the parking lot back to my car, it was a red F-150 approached us, and as we were walking, the guy, it was a bald guy, he said, "Angel, get in the car." So I'm like, okay, well, I'm not gonna stop you for getting in the car if that's what you want to do. And Angel like, no, I didn't come here with you, so I'm not gonna leave here with you.
All right.
You know,
Did you know that individual that was in the vehicle?
I'm familiar with him. I don't know him.
Okay.
I'm familiar.
Okay. So can you explain how you're familiar with him, how you know him?
I believe him and Angel was in a relationship with each other before.
Okay.
So I'm really close with her brother, Terrence, and I've met him through Terrence.
Okay. All right. And just clarify, what kind of relationship did you have with Miss Robinson at the time?
We were just friends.
Okay. And was there any other prior relationship prior to that?
No, I wouldn't say relationship. We were just real cool. Like real cool. Like I knew her since I was a kid.
Okay. And then after that, you had said earlier that the red truck came up and he had called her over. Can you start from there? What happened after that?
As we asked her to come over, Angel said, "No, I didn't come here with you." So it was more like him waiting to see what car she was getting in. So he kind of sat there with traffic backing up behind him. So at this point, I'm like, Angel, come on, or you know what I'm saying, I'm leaving because I don't want to be involved with this type of stuff. And she was like, I'm trying to, I'm trying to. So as she was leaving, he kind of like snatched her into the truck. So I'm
Okay.
like,
Let me stop you there. When you say he snatched into the truck, can you explain what that looked like to you?
like you know, like you walking and someone's like trailing you with their vehicle. It was like we're walking, and then he was like, well, Angel, get in the truck, and she was like, no, you crazy. I don't even deal with you. I'm not about to get in the car with you. I didn't come here with you. And then he was like, okay, all right, all right. So then he kind of like opened the door a little bit. And when he opened the door, he kind of snatched her, but he kind of snatched her through the window. So at this point, I knew it was like a problem. So I'm like, I'm leaving. You know what I'm saying? So I proceeded to my car and, you know, to get her belongings because I don't want to be involved with this. You know what I'm saying? So then it was like, I'm like, no, she can't. It was my decision. We came down here. So I want to make sure I get her back home safe. I picked her up, so I want to take her back home. So as I'm leaving, she was walking towards the precinct downtown. She was walking towards downtown, and I pulled on out of the driveway of the Lexington Center, and I kind of parked. And Haywood put on the side of me. I believe that's the name. And he put on the side of me, and he was like, she, you can have her, you can take her home or whatever. I said, I ain't got nothing to do with this. I just want to make sure she get back to the crib. So he took something out of his car.
When you say the crib, can you explain that term for us? What does
Get
that
back home. I wanted her to get back home.
Thank you. Yep.
Cause I like it was a lot going on with her. Like I said, like her brother was my friend. She lost her brother, and I wanted to just take her out and have a good time because you know there was a lot of sad stuff going on with her. So it was like I can't leave her out here because I would hate that. I would hate for something to happen to her and that be on my conscience. So I'm like, okay, I gotta get her back home. So at this time, I noticed her mouth was bleeding. So I was like, okay, well, I want to make sure she get home. So she was walking towards the precinct downtown, like I said, and the red truck was parked at the stop sign. So I'm like, now if she makes it to the stop sign, maybe something, you know, bad will happen. So I'm like, Angel, get in the car, please. Get in the car. So she got in the car with me, and I dropped her back off at her house.
Okay. Let's kind of go back on some of the finer details earlier. You said that he snatched her up from the car, right?
Yeah.
Was he outside of the car at that time? Was he inside of the car? From your perspective, how did you see that?
It was more like it was so close to like if he would have swung the door open, he could have hit both of us with the door. Because it was like a parked car, his car, and a whole bunch of cars behind him, waiting to see like if he gonna move. They were honking their horns and everything. Like,
so were you guys in the street or in the parking lot?
We were in the parking lot of the Lansing Center, on like that on the side parking area right there,
Across from the lug nuts?
Across from the lug nuts.
All right. Okay. And did you witness? How close were you to the truck? You said you could have got hit by the door.
Yeah, I could have got hit by the door when he opened the snatcher up. Okay. When he did that, I'm like, okay, well, I'm not gonna make this as if it's two guys arguing over a female. I'm gonna leave because I don't want any parts of this. So
did you have any of Miss Robinson's belongings?
Yeah, I had her purse in my vehicle.
Okay. Do you know what the contents of the purse was?
No, nothing. I don't think it was nothing really in there because I paid for everything. So it wasn't, she didn't really need anything.
All right.
So I think it was more like personal items, like you know, maybe like deodorant or something like that. Like I didn't look in her purse or anything.
Okay.
But I know like before we went to a comedy show before that as well. And before that, she put her favorite perfume. So that's what I would think would be in there.
Juror number one had his hand up. Was there a question, juror number one? Because if so, you would just write it down. Oh, okay. You just had your hand up. Okay, excellent. You can proceed.
Thank you, Your Honor. Do you recall if Ms. Robinson had a cell phone on her at all?
She had her cell phone. Yeah.
Do you recall if? So did you witness anything that she did to his vehicle?
No. Only thing I witnessed is her fighting to get out of the vehicle.
Okay.
To get out.
So was she ever in the vehicle at all?
She was inside the vehicle. Yes, her legs were. If over half of your body is inside the vehicle, then you're inside the vehicle.
So you're telling. So let me clarify. So he had pulled her into the vehicle.
Pulled her into the vehicle, and that's where the tussling. That's where I saw the tussling part. Okay. Like I saw her trying to defend herself towards him, hitting him. That's when I believe his glasses or something came off when they were inside the vehicle. But she was just trying to, get out.
And earlier you had stated that you saw that she had some injuries. Is that correct?
Yeah, her mouth was bleeding when when I seen her walking. That's the only reason why I stopped. I'm like, yo, this is crazy. Like, cause I felt like it was my fault because I brought her down there. You know what I'm saying? She just like, she just wanted some chicken from the nut house. That's where we, usually go, me, her, and Terrence, for like family fun nights and stuff. So.
All right, may I approach your honor?
Okay.
Ms. Melvin, I'm gonna show you something, what are marked as defendants proposed exhibits A, B, and C. Can you review these, real quick? And I'm gonna ask you some questions about it. Can you tell me if those fairly and accurately depict the injuries that you witnessed that night?
Yeah.
Okay. And to best of your knowledge, and that person who was in there, can you identify who that person is in that photo?
Andrew Robinson.
Okay. Your Honor, I'd move for admission of defendants A, B, and C.
Any objection to defendants A, B, and C?
Just brief voir dire, Your Honor.
Proceed.
Oh, geez. Were you present when those photos were taken?
No.
Okay. Do you have any, outside of just saying that statement, do you have any personal knowledge of when those photos were taken?
No.
Okay.
It's the first time I've ever seen it.
No other questions, Your Honor.
Any objections to admission of A, B, and C?
No objection, Your Honor.
Defense A, B, and C are admitted.
Thank you, Your Honor. Mr. Melvin, can you look at defendants A that has been admitted? And can you describe to the jury or to the court what you see there and show that kind of hold it up and kind of describe to the court what you're seeing and what injuries are there?
This her mouth being busted open from a physical altercation. So that's what I see.
Okay, and is that accurate to how you saw it when you got her back to the vehicle?
Yes, sir.
And based on your observation, who did that? Who created that injury on her?
Objection, Your Honor. Calls for speculation.
You said based on your observation?
Yes, Your Honor. It's based on his observation. Whether or not he saw that, I'm asking if he saw how that injury happened.
Well, I don't think it's cause for speculation if it's based on his observation. So to rephrase it would be the same as did you see how that happened? So the objection's overruled. You can respond.
Did you see how that injury happened?
Yeah.
Okay. And do you know the person who caused that injury?
Yeah.
Okay. Who was that person?
Hayden.
Okay. Did you witness Miss Robinson fighting back at all?
Yeah, when she was in the vehicle, I seen her fighting them back to get out, and everybody like, "Are you gonna help?" I'm like, "No." Like I didn't want to put myself in that position to where I feel like I could get out of line with someone on behalf of someone else's, because I didn't know what they had. If they were still talking to each other or what was going on. All I know that he seemed upset and he demanded her in the vehicle, and she did not want to go.
Okay.
So I'm like,
so
okay.
that was your impression of that altercation.
Yes, yes, sir.
All right. Your Honor, may I publish to the jury?
Okay.
Did you witness any altercation after that? After the window incident?
No, well, like I said, when I pulled to the outside of the Lansing Center to pick her up, like I said, he pulled on the side, and that's when he got out with the whatever it was in the cup. Like I said, I'm not sure what it was, but when she got back into my vehicle, it smelled like alcohol. So I'm like, okay, well, maybe that's what he was throwing on it. You know what I'm saying? But before that, like we didn't even with no drinks or nothing was seen the whole night.
So to clarify that, you guys were at the nut house, is that correct?
Correct.
And you guys consumed some food, is that correct? Did you consume anything else besides food?
Nope, just food.
No further questions, Your Honor. Thank you.
Cross-examination.
Good afternoon, Mr. Mullin.
Good afternoon.
So, Mr. Melvin, you and Ms. Robinson were at the Nut House, correct?
Correct.
Okay. And you said in your testimony that neither of you were drinking at that time, right?
No.
Okay. Was anyone else in the restaurant drinking?
It's a bar. I believe everyone else was there was drinking.
Okay. So, would it be possible that the smell of intoxicants was coming due to you and Miss Robinson being present at a bar where others were drinking?
No, because after the club, we were outside. So if it was a smell of alcohol on me, it would have dispersed when the air hit me. We're standing outside trying to figure out what was going on with her.
Okay, so you said you left the Nut House, you crossed the street, correct?
Correct.
You saw the red truck there.
Correct.
Now, was the red truck stationary or did it move to approach?
It moved to approach. It was in, like, you know how you drive around looking for a parking spot?
Mhm.
It was like parked right there. Like it wasn't in a spot, but it was like in between, like, you know, like a car parked the long way, then the Lansing Center's here, so like cars parked, you know, vertical and horizontal. So it was like the parking lot that small, not that big. So it was like he was right there facing the club.
Okay, and as you were leaving, did you notice any vehicles or anything backing out of their parking spots at that time?
It was everybody was backing out, trying to leave, trying to get out the parking lot. The
Okay.
event was over with.
So you said then that the driver of that car called Miss Robinson over.
He didn't call her over. He demanded her to get in the vehicle as if she was leaving with him.
Okay, but did she approach the vehicle or did the vehicle approach her?
He approached us. When I walk, especially without like a female, I make sure I'm towards the street or towards whatever the incoming traffic is. So it was more like me here, his truck, then her. And then it was like when he said get in the car, I'm like, okay, well, I'm getting into my car because I don't, whatever y'all got going on, y'all handle it. I'm gonna get in my vehicle. So I proceeded to my car to get her belongings as if she was gonna leave because I didn't know what was going on. She was trying to get away. She was following me, but he kept trying to make her get in the car.
Okay, so did you see her actually approach the vehicle or did you walk away before she approached the vehicle?
She didn't approach the vehicle. It was more like, you're coming with me. As I'm walking away, he snatched her into the vehicle.
Okay, but you said you're walking away. Does this happen in front of you or behind you?
It was more of like, you know how like, my car's right here. So it's like I'm going to my vehicle and I'm watching to see what's going on and to make sure she's following me. But as soon as he see me walk away, that's when he just, pulled her into there.
Okay. You also mentioned during direct examination, you said that initially that he opened the door, but then he, as you said, quote, snatched her through the window.
If he would have opened the door, he would have hit the other vehicle that was parked right there. That's how close it is in that parking lot. It's not that big of a parking lot to where you can get out the car and do things like that. It was more like vehicles and chaos, everybody trying to get out behind him. Because it's only one way in that parking lot. So it's people walking in, people walking out to get in their vehicles. There's people trying to pull out to get out of the same parking lot. So there's only one way in the parking lot. So either way it goes, you're gonna have to pass whoever walks in, or you're gonna have to pass whoever walks out.
But I guess my question is, you said on direct examination that he opened the door and grabbed her, but then you said he grabbed her through the window. So I'm guessing which one is it? Did he grab her through the window or did he open the door?
There wasn't enough room for him just to directly go like that. So he had to get some sort of leverage for himself. So he opened the door just a crack to, grab her. It's more like, okay, if I'm going down the street and I see something and I just open my door a little bit and grab it up. That's exactly what he did. He opened the door, snatched her through the window because his window was down.
Okay. And then you said, you also said on direct that, again, you were walking away. Did you see did you see, I guess, the conclusion of the interaction between Mr. Greenwood and Ms. Robinson?
Only thing I seen was her turn the corner, and that's when I seen her mouth bleeding. Cause I had pulled in front of the thing, in front of the Lexington to see if, make sure she was getting home or where she was going, cause I still had her belongings with me.
So is it fair to say that you didn't see the whole interaction and don't actually know what happened between the two of them?
I mean, I seen the whole interaction because I'm the one who dropped her off at home.
But you said you were walking away from the vehicle and didn't see the end of the interaction. You just saw her turning the corner.
I got in my vehicle to leave, but I couldn't leave her. I brought her there, so I had to take her home. That's just me. Like, I felt like I was responsible because she didn't want to come. It was my choice of wanting to go to that restaurant. So I was like, okay, if I bring you here, I pick you up safely. I'm gonna drop you back off at home safely.
Okay, so is it fair to say that you were concerned whether she got home safely or not, but not how this interaction with Mr. Green would turn out?
Correct.
Okay.
Like I said, I didn't know if they were still seeing each other or whatnot. So I'm not gonna put myself in a position to where I get involved and they still talk to each other or whatever. So it's like, well, it is what it is. I'm gonna leave. I'm gonna exit the situation. But then I'm like, well, she just lost her brother. So if anything happened to her, I would feel bad because that was my friend too. So I was like, I would feel bad if anything happened to her after this. So I'm like, let me get her home.
So you were stating when you were walking to your car where your vehicle was parked, you had to walk past the truck to get to your vehicle, correct? All right, and you said that this parking lot is so narrow that you can't really open your doors if you're in between the two aisles of cars, correct?
Correct.
Okay, and that traffic was backing up behind the vehicle.
Yeah.
Okay, but then you also stated that after you pulled out of the parking lot, Mr. Greenwood pulled up alongside of you.
Correct.
So I guess my question is, how did you get your vehicle out of the parking lot past Mr. Greenwood's truck in order to have
I'm not
him?
gonna lie, I went the opposite direction. I went where it says do not enter, where you're supposed to go around. Like everybody was back up behind him. So the way you come in is the way I went out. You couldn't go out. Only way you can go out is the way you come in. You get what I'm saying? Like, so it's like I went the opposite direction of traffic to get out.
So when you say then you saw Miss Robinson around the corner, was this the corner exiting the parking lot going the correct way of traffic or the corner going the opposite way of traffic?
It was the corner going. It was the side door of the Lansing Center. So whatever direction is coming towards this way, coming towards downtown, it was like coming to to your right.
Well, no, but my question is, sir, did you see her as you were leaving the parking lot?
I seen her as she was walking down the street on Lansing Center. She was walking towards the jail or something. Like it was more like the middle doors is where I picked her up from. The middle doors of the Lansing Center.
So there was a considerable amount of time, I guess you would say, comparatively, that passed between when you left Miss Robinson at the interaction with Mr. Greenwood and when you saw her.
I wouldn't say it was a considerable amount of time. I just feel like she was trying to get away. So that's the reason why I even approached her back.
In your estimation, how much time would you say passed?
Maybe like 5 minutes or so.
Okay.
Because he had threw her purse too. So I had to figure out, where her purse was in the middle of the street. Because I took the purse out and laid it on the vehicle. Like, if you're gonna leave with him, here's your belongings. You know what I'm saying? But then when he threw it, I'm like, man, I'm not about to leave. She started walking, but I'm not gonna leave her. So I just grabbed her stuff and picked her up, took her back home.
So was Mr. Green? So then, before you left the parking lot, was Mr. Greenwood's truck gone then?
No,
at that point.
This truck was still there. The traffic was honking. The horns were honking, and they were asking him to leave, or they were asking me to get her. I'm like, well, I'm not about to approach anything. I'm gonna let them do what they're gonna do.
Well, but you just said that he had thrown her belongings off of his truck.
No, I never said he's gonna. I said I put her belongings on a cart that was next to his truck. When I pulled up on the side, I took out her belongings. That's up on the vehicle right next to his truck. So if they wanted to leave, it was her choice. Either she was gonna leave with him, or she could have left with me. You know what I'm saying? But I wasn't gonna make her do anything. I wasn't gonna say, Angel, you come with me. I wasn't gonna do that because she's an adult. So she were fighting to get away. He took her purse. He said, I'm not taking her home. He took her purse, threw it. I got it out the street, waited for a second. When she started, as she was walking, I approached her and told her to get in the car because I seen him parked down on the other side, like in front of the Radisson. So that's when I did a U-turn in the middle of the street and took her back home.
Second, Your Honor. So I guess I'm just trying to get the order of events here because it's not quite making sense to me. So you walked to your car and you got her belongings out of your car, correct? And you put them on a different car.
Yeah.
Okay. But then you left before you saw how the end of the interaction between
I left out the parking lot.
before the end of the interaction between Miss Robinson and Mr. Greenwood.
No. Like I said, where I parked at was right outside of the Lansing Center. So when you pull out the Lansing Center, it's right there. Like it's parking spots right there. Like when you pull out the side of the Lansing Center, to your right, there's stuff right there. I'm sorry, that's my alarm for work. I'm sorry.
So I guess let me see if I can ask this in a different way. When you picked up Miss Robinson's belongings again, was the interaction between her and Mr. Greenwood still going on, or had it ended?
It was still going on.
Okay, but you didn't know if she was leaving with him that night or not, did you?
It wasn't it wasn't my concern until I seen her mouth moving. That's when I felt like, okay, well, something's wrong. I gotta get her back home. I felt bad because I was the one bringing her.
No other questions at this time, Your Honor.
Can you read it right?
Just briefly, Your Honor. At the nut house, you didn't have any alcohol spilled on you.
No.
And when you left the nut house until the drink was spilled on you, on Miss Robinson, you didn't smell alcohol on you or on her. Okay. And to clarify, did you witness any damage done to the red truck at all?
No.
No, you didn't witness any damage. Okay. All right. And there was a time when you weren't paying attention to the incident. About how long was that when you were going to your vehicle? Did you witness the whole thing the whole time? Can you clarify that?
I can say I witnessed the whole thing the whole time because I want to know what's going on. Like this person came with me, so if something happened to her, I want to be able to tell her mom, like, well, this is what happened. You know what I'm saying? So, but I did want to get myself out of that position. Like I didn't want to be involved with none of it because that's not who I am. You know, I didn't want to be involved with it.
Did you go? So after you picked up Miss Robinson, did you go anywhere else after that, or did you go straight to her?
I went straight home.
Okay.
I dropped her off at her place. Then I went straight home.
No further questions, Your Honor.
And does the jury have any questions for this witness?
No.
Okay, no questions. Okay, thank you. You may be excused, sir. You can call your next witness.
Thank you, Your Honor.
Actually, it's been over an hour. I need to give the jury a break and they need to go see Treasury so they can get their payment before 4 o'clock. So we're going to adjourn. You can follow Mr. Bigelow, he'll let you know where you need to go to collect your payment from the Treasury Department, and then we'll see if we can get administration to bring you some snacks. We'll adjourn for about 10 minutes. Okay, you're back on the record. You can be seated and defense can call their next witness.
Your Honor, the defense calls Angel Robinson.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat there. Okay, Ms. Robinson, you understand that you have the right to remain silent. Anything that you say can be used against you, correct?
Yes,
And you understand that by waiving your right and giving testimony today, you give the prosecutor the right to cross-examine you. You understand that?
yes,
And you understand you have the right that you don't have to present any evidence today or any defense on your own behalf. You recognize that? You wish to waive your right to testify today?
no.
You don't,
talk.
you want to testify?
Yeah.
Okay, and so that means you have to waive your Fifth Amendment right to do that. That's what you want to do?
No, I don't understand.
So you have the right to not testify at trial today. You recognize that, correct? You discussed that with your attorney?
Yeah.
Okay, you want to waive that right and testify?
Yes,
Okay, is anybody threatening you to get you to waive your right?
no,
Okay, any promises being made to you to get you to waive your right to testify today?
no.
Okay, you can proceed.
Thank you, Your Honor. Ms. Robinson, again, just want to go over, we talked about you testifying today, is that correct?
Yes,
And it is your decision to testify today, correct?
yes.
All right, thank you. So I want to point your attention back to November 5th of 2022. Can you tell me anything significant that happened that day?
Yes, I woke up, fairly late, having a rough morning. My brother had passed away less than 30 days before. Courtney had called me, been calling me to just get me out the house, but I just didn't feel like going. I didn't want to smell nothing, see nothing. I was not with my brother. So finally, it was like, we're not even going to be in Lansing. We're going to go to the comedy show, which was in Detroit. We went to the comedy show in Detroit. It got over about 11. No, it was about 10. So we came back, went and got some dinner. We went to karaoke too. Went and got dinner. So after all of this, we were on Michigan Avenue at the series of restaurants, which are like Nut House, Duke, Tin Can. As we were exiting on Michigan, we're walking across the street. Okay, so the Lansing Center is here, and then like Nut House is here, but it's all like facing like this, and I'm walking across the street type situation. So we're leaving, me and Courtney, the big guy, and Haywood in the red truck is at he's like not in a parking spot, but it's like we're about to leave out. So he's just in the middle of the parking lot, not parked, but just here as if he's leaving, but he's just like in a stance where can't nobody go around him. I'm like, they're behind it. So we're walking across the street and I see the truck, it's this big old red truck. So I let Courtney know, like, that's Haywood. And he was like, okay. And I'm just like, okay. I had just made him aware that me and him had just had words a couple of days ago. And we let him know I didn't want to see him anymore because he would just pop up. He's everywhere I'm at. He's 2 minutes away. He's just everywhere. It doesn't matter if I'm at my mom's house. Well, I'm around the corner. Let me come see you. Like every time. So just previously, that's why I wanted to show those messages. I
Hold
told
on,
her.
So
Oh.
let's focus back on you
Oh,
were
that
crossing
night.
the street.
Okay.
Yes.
So I was crossing the street and then I seen Haywood and then I, so forth. So long story short, we got over there walking. So we had to kind of walk past his truck by the way he is and the way Courtney's parked like back behind his truck and he's like blocking everybody. So we was walking like towards his truck, but like on the side. He's kind of itching out like he's about to leave, but he's not. So we're walking like right past it. And that's when he was like, get over here, come over here. Something said crazy, but I like was walking towards his truck, but not towards his truck, but it's in the way. So I have to go that
So
way.
to clarify, can you tell me where the truck was in association with the sidewalk, the straight
Okay, so-
sidewalk and the parking lot? Can you explain that?
He was already across the sidewalk area, but he's in the driveway of the Lansing Center. So you got your sidewalk and then you got your entrance, but he hasn't left yet, but he's like going to leave, but he hasn't went in the street yet. So he's in the exit of the parking lot
Has he
Like-
crossed the sidewalk yet?
a little bit. And because he was moving out, as he seen us walking across streets, like he was like pulling forward, like he was inching.
So explain to us what happens after that.
So I'm like walking past, he's like, get over here. And so I'm already walking toward the vehicle. So he literally, I walking past the vehicle, he snatches his arm out and like grabs me up to his vehicle. So I'm like on the,
Okay, let me slow you down. So you say he snatched you. Can you explain to the court where he snatched you, how he snatched you? Can you explain that in more detail?
So I'm walking by, I literally stop and I look at him like, you know, and he snapped me like up by my powers. And then that by this time, okay, I had on a black leather jacket, so he like this.
And the record reflect that Ms. Robinson is
Oh,
holding
he snatched
the
me by my
collar
collar of my black
of
leather
her-
jacket, and I have marks from like where I was grabbed. And he like this.
Okay, what happened after that?
And that's when I was like flying in the air on his running board type thing, and then he punched me in my face. He threw a drink at me. No, he threw the drink first, and then, but this is why he holding me with one hand. It's like he's multitasking. He held me with one hand, he threw the drink at me, and then he like punched me 2 times, and then that's when I fell. Then he got out, and then when he said I was like messing up his truck, I feel like when I'm swinging, dangling in the air, I didn't intentionally like try to kick it, but I may have when I'm mid-air swinging like a little monkey or whatever. So,
Let me slow down a little bit there. Your Honor, may I approach to retrieve the exhibits A, B, and C? I'm gonna provide you with what's been admitted as defendants A, B, and C, all right? Can you describe what is in exhibit A to us?
my lip is busted. I have some scars right here, and I was like grabbed up. I was punched in the face, like over on the side. They punched me like 3 times.
Okay, and who took these photos?
I took them.
Okay, and how quickly after this incident did you take them?
I got home probably within an hour. It was within an hour because it had started to like,
And these are accurate to when you took that, is that correct?
yes,
All right.
within 24 hours.
Can you explain to us how these injuries made you feel?
Unsafe, ugly, vulnerable. I feared for my life. Did not want my kid to see me like that.
Okay. So let's go back a little bit to when you said that he snatched you into the vehicle. Can you explain that some more? Where did he snatch you into the vehicle? Was it the window? Was it the door? Can you
It
explain
was
that to us
his
some more?
front door. It was a front driver door. It was on his side through the front driver door. Like the window was a little cracked, but by the time he seen me, the window went all the way down. And he snatched me up like through his front window, through the front driver door.
Okay, so let me just clarify. Is it the window that you rolled down, or is it the cracked door that you went in?
No, I went through the window.
So
Yeah, like you know how
pulled you up and
Yeah.
and over into the
it looked
window.
like he was about to get out, and he did, but his window was down. So he grabbed me, and I don't weigh that much. I went up. He
Okay.
snatched me up through the window. It wasn't the door was never fully open at the time where he snatched me up.
Okay. And then how long was that interaction before you were able to regather yourself on the ground?
I guess after I scratched him, he unhanded me, but I was like you said, I was windmilling in there. I didn't know what to do. I'm fearing for my life. Like you didn't snatch me up in this car. I don't know if you was about to kidnap me or whatever. So I'm in the car fighting, you know, I'm
Okay.
I'm
And so
through
once-
this window.
Once you're out of his grasp, can you explain what happens after that?
Once I get out, I fall out of the front door. And then that's when he get out. And then we started tussling some more.
Okay.
But and that's when he was like, I was trying to walk away, and then because Courtney was leaving, but he got out then because he big mad. He was already a little mad that he seen me with Courtney, but he big mad now.
Okay. And so could you describe kind of not what he said, but what he said made you feel when you were approaching? You don't have to. I don't want you to say what he said, but the words that he used. How did that make you feel when you were approaching that?
He made it feel like I was a prostitute. Like I just out there using people. Because I wasn't with him, I can't be with nobody else. And that's period.
And can you explain his tone of voice? Was it calm? Was it, in your opinion, how was that?
He wasn't calm, he was shaking, like he was sweating, he was shaking, he looked like he was about to blow a lid, like. If you talking about, I look like I got caught, I was looking scared because you are crazy.
And then let's go to now, you said that you're out of his grasp, and then you guys tussled with him. Did you
Yeah.
receive any injuries during that tussle at all? Do
Yeah,
you
that's
know?
when he punched me in the forehead.
Okay, can you
Oh,
show
sorry.
the,
That's when he punched me in the forehead. I got punched like 3 or 4 times. I got punched right there, but at that time, and then he said I didn't have anything to hit him with. I'm like I said, I got nails, but that's how I scratched him with the nails. But I didn't have nothing to damage nothing. I didn't have a purse. I didn't have anything. That's why I was leaving him because I was like, I would get sex trafficked.
so the, can you explain what happened after you tussled outside of the vehicle? What happened after that?
I got out and tried, well, I was already out. I got up and started walking around the vehicle to leave. I didn't even know which way to go. I just was looking towards home. So I started walking down Michigan towards Lansing. We're already in the Lansing Center, but I started walking in front of the Lansing Center. So if I go that way, I'm walking away from the Lansing Center. I started working towards that way because thankfully I live down Washington. So I started walking towards Washington.
So we say towards Washington, you mean like towards the Capitol?
Yeah, yeah.
Okay, so
yes.
from the Lansing Center, you started walking towards the Capitol?
Yes,
Okay.
because I was gonna walk home.
Okay, so what happened after that?
He started following me. Haywood started following on the side of me in the red vehicle. Courtney was already like behind, trying to pull out, but he was directly on the side of me, just in slow motion, talking about, you're gonna end up in prison with your brother. And that's what he just kept telling me. Don't even worry about it. He told me he's gonna do all these things and all that. So he just followed me on the side. Then Courtney was like, get in the car, get in the car. So then he sped up to like the stop sign and then he got out. But that's when I got in the car because I'm like, oh, ain't nobody got no more energy for this. So when he pulled up there and he would got his vehicle, I got in the car with Courtney and he took me home.
Okay. Did you have any other altercation with Haywood after Courtney took you?
Yeah, he called me. He called and threatened me. He said, watch what I
Objection,
do.
Your Honor, here, sir.
Oh, sorry.
No, I'll restate the question.
Okay.
Did you have any other physical altercation with him?
No.
Okay. Have you had any contact, without telling me what he said, have you had contact with him after this incident?
Yes.
Okay. And how soon after this incident was there contact?
Within hours.
Within hours? Okay. All right. What was your relationship with Mr. Haywood?
We dated
Okay, how long?
5 years.
Okay, and when did you guys stop dating?
We never stopped dating.
Can you keep your voice up, please?
Oh, we never stopped dating.
Okay, so you guys were kind of on and off, or is that correct?
Yes.
Would you consider him a jealous type?
Very much so.
No further questions, Ron.
Cross exam.
Yes. Good afternoon, Ms. Robbins. So just to, I guess, work the timeline here a little. So you and your testimony is that you and Mr. Melvin went out to a comedy show in Detroit and then came back to Lansing after that, correct?
Correct.
Okay. And then as you were leaving, what bar were you leaving that night?
We wasn't technically leaving a bar. It was a restaurant, sports bar and grill, nut house.
Okay. So after you were leaving the nut house and you're crossing the street, you see the red truck there. And after you crossed the street, did the red truck pull up to you or was it stationary at this point?
It was rolling forward. As we were walking, he was like moving forward. That's how he got across the like sidewalk. He was sitting still for a minute, but as I was walking across the street, he started pulling out towards me. No.
So he was just pulling out towards the road.
No, he like was pulling out towards me. Well, except yes, because I'm in the road.
Okay.
But he never left though. He never left. He never got in the road. He never left the scene
Okay.
as if he wanted to leave. He was the first car.
Okay, and then, so you then stated that as you and Mr. Melvin are walking past the car, that was when, at least according to your testimony, you said that was when Mr. Greenwood threw the drink at you?
Yes.
Okay. All right, and then, again, you said he grabbed you and,
Wait, may I say something? I wasn't walking past, like I had already stopped
Ma'am,
right in front of me.
you answered the question? So you said after he pulled you in, you scratched him. Do you recall what hand you scratched him with? Okay. So then after, said he pulls you into the car, there's the altercation, and then you end up outside of the car, and then he exited the vehicle?
Correct.
Okay. And did you have your phone on you at this time?
No, I didn't.
Okay.
My personal phone was all in Courtney's car.
Okay. So after, okay, so after the altercation then happens in the parking lot, you said you started walking down Michigan towards the cafe, correct? And that was when
Yes,
Mr.
Sorry.
Yep. And then that was when Mr. Greenwood pulled up alongside him,
Yes.
correct? So where was Mr. Greenwood when Mr. Melvin picked you up?
Right there, like literally in the lane directly on the side of me. I'm here walking on the sidewalk. He's in his vehicle right here trailing, but in his vehicle right there. So Courtney pulls because it's multiple lanes and then he pulled around like, come on. But as he stopped, Haywood started yelling at Courtney. And then when Courtney stopped his car, Haywood took off to the end of the road and stopped right there and got out. When I seen him get out, I got in Courtney's car.
Okay, so you didn't get into Mr. Melvin's car before Mr. Haywood left. Mr. Haywood left after you got into the car.
Repeat that question.
Did you get into Mr. Melvin's car before or after Mr. Haywood left the scene?
He never physically left the scene. He pulled forward a little bit and got out of his car. So I got in while he was still there. When he pulled up in front of Courtney's car, he got out. So I got in because I didn't know if he still wanted to tussle.
Okay.
So I'm sorry, I really don't understand. He never left the scene technically. He pulled a little bit ahead and I got in because he got out.
I'm just trying to clarify because I believe it was previous testimony from Mr. Melvin that Mr. Greenwood pulled up alongside his car and then left and never exited his vehicle. So I'm just trying to clarify the
No, I
timeline.
never said Haywood got out of his vehicle. I said not right when he was on the side of me. He pulled up in front of us and then he got out. When I was walking, he was trailing me in his vehicle. Then when he seen Courtney, he pulled up in front of us, like down the road type thing. And that's when he got out of his vehicle. I got in Courtney's vehicle. He was not trailing me on foot. He was still in his vehicle at the time when Courtney picked me up.
Okay.
Him getting out of his vehicle up the road caused me to get in because I was walking to my home.
And so did you ever report this incident to the police?
Yes,
And how long after this incident did you report it to the police?
the next day.
One second. All right. So when you said, I'm just going to back up a little bit because I want to clarify one other thing. So you said you were heading to, you and Mr. Melvin were heading to Mr. Melvin's car. And that, correct?
At what point?
after leaving the nut house, you and Mr. Melvin were heading to his car in the parking lot,
Yes, I
correct?
rode with him.
Okay, and you saw Mr. Haywood's vehicle there, and were there cars behind Mr. Haywood's vehicle?
Yes.
Okay, and were those cars blocking in Mr. Melvin's vehicle?
What do you mean blocking it? Like, so he couldn't move?
Yes, like so that could he have backed out immediately based on where the position of Mr. Haywood's vehicle and the other cars behind him?
Well, yeah, because he, like, they're in a straight line to come out. He's parked like, they're straight, and then these are how you can park this way. So you see what I'm saying? The exit is this way, and then you park these ways. So where Courtney's car is somewhere along this area, so I don't see how he would be obstructed by Haywood's vehicle way over here if he's parked this way type situation.
So are you saying his car was parked perpendicular to the way Mr. Haywood's car was facing?
Give me a visual. Okay, look, I just told you, Haywood's car going this way, and Courtney's car going this way. What is this, horizontal?
If that's your position.
I-
Could Mr. Melvin have moved his car with No further questions, Your Honor.
You redirect.
Thank you, Your Honor. Just briefly, so when he pulled you into the vehicle, how did that make you feel?
Weak, helpless. And I'm
And
about to die for real because that first punch was like,
so, and explain to us again, what were you doing to try to get away again?
windmilling. I don't know what I was doing. I was like, probably screaming, but I know I was like this, like, because I got long nails. My nails are always long. I'm a nail tech, by the way, so my nails are always long. I can't ball my fist up because my nails are always long. So I know that's why I didn't deny him saying he got scratched. I wouldn't deny that because I always have long nails. So I'm not gonna say I didn't scratch him. I'm not gonna say I didn't cause a damage on the side of the door because I was windmilling and kicking, but I didn't break no windows. I just snatched me up in there and I don't know, because I was doing like this. I don't know how much room you got to really fight somebody when they got you through that's awkward as hell, first of all.
Further questions, Your Honor. Thank you.
Thank you. Maybe, any questions from the jury first? Questions? Okay, did you write it down? Okay, can you get their questions, please? Okay, Ms. Robinson, when did you retrieve your phone?
When I got in the car with Courtney, because he still had my stuff. Like, I don't know when he picked it back up or when, because I do remember him like sitting on somebody's car, but then it was in the middle of the street. So I didn't even know he had my stuff.
Okay,
I got it when we got to the house out of his car.
you retrieved it from Courtney. Was it in your purse or
Yes,
was,
it
okay.
was all my stuff was still in my purse.
Does that answer your question? Okay, any other questions from the jury?
I have a question.
You can write it down. I'm not sure if this question, that's not a question. You have them rewrite it. Take your time to write it. You don't have to rush. You gotta withdraw your question. Okay, sounds good. And no other questions from the jury? Okay, Ms. Robinson, you may be excused from the witness stand. You can call your next witness.
Your Honor, the defense has no other witnesses or proofs.
Okay, sounds good. We'll take a brief recess to go over some final instructions, and then we will allow you to do your closing statements and final instructions all in one setting. All rise for the jury. Okay, we'll be recessed for 10 minutes. Can you pass me all those exhibits and the ones that are still on the jury box? Yes, thank you. You can be seated.
Whatever you want to
Okay, thank you. You can be seated. Okay, ladies and gentlemen of the jury, if you want to fix your attention to the screen, we have one last set of instructions here. These instructions will begin shortly after we hear our final, our closing statements, and we'll have the prosecution go first.
Thank you, Your Honor. Good afternoon again, ladies and gentlemen. Thank you for bearing with us. I know it's warm in here. I'm a little envious of those of you with short sleeves. So as I stated in my opening, the defendant here has been charged with the crime of malicious destruction of property, to wit, a truck, and you've seen the evidence to that. The majority of that evidence came through testimony. And I would ask that when you're back there and you're deliberating, that you pay attention to that testimony and you pay attention to the consistencies and the inconsistencies of that testimony. When we had the victim, sorry, Mr. Greenwood, up on the stand, his testimony was consistent. Through direct examination, through cross-examination, even back to redirect, and he even corrected himself a couple of times. Where we really saw inconsistencies would be in the testimony of the defense witness, Mr. Melvin, and of the defendant herself. And let's look at a few of those inconsistencies. We see from all three versions of events that the defendant and her friend were leaving the nut house. They encountered Mr. Greenwood in his vehicle in the parking lot of the Lansing Center. But that's about where the similarities end. We had testimony from the defendant that as her and Mr. Melvin were walking past the defendant's car, that was when the drink was thrown at it. However, we had testimony from both Mr. Melvin and from the victim, Mr. Greenwood, that drink was not thrown until after the altercation had occurred and while the defendant was walking down the road. We also have testimony from the defendant that she did not have her phone on her at this time. However, we had contradicting testimony from the victim, Mr. Greenwood, who says that was the instrument she used to bash out his taillight and his rearview mirror. And we also had, again, testimony from the witness, Mr. Melvin, that she had her phone on her. We had testimony also from the witness, Mr. Melvin, who initially said that he didn't see the whole incident and that it was behind him and that he just, allegedly saw her get pulled into the vehicle. But then on cross-examination again, said he did see the whole thing. We also had testimony from that witness that he was worried about his friend getting home that night after this incident, but apparently wasn't worried about her when she allegedly got dragged into a vehicle. And that's what I would ask you to pay attention to here, ladies and gentlemen, is the consistencies and the inconsistencies between the witnesses' statements. We have very consistent statements throughout the entire testimony from the victim, Mr. Greenwood, and we have contradicting statements from both the victim, from both the defendant and the defense's witness. I would also urge you, ladies and gentlemen, to focus, as you'll be instructed by Judge Simmons, to focus on the elements of malicious destruction of property here. That there was property owned by someone else, that property was damaged, that the person who damaged that property did so with the intent of damaging that property, and that the value of that damage was somewhere less than $200. Testimony from Mr. Greenwood, which was the most consistent testimony that was up there, was that there was an altercation that occurred in the parking lot, and that during this altercation, the defendant, Miss Robinson, used her cell phone to smash out the rear tail light and the side view mirror of his car, and she also kicked the door. Based on these facts, I believe that the only verdict that you can come back with would be, and that we would ask you to come back with, would be verdict of guilt.
Thank you, Your Honor. Gonna go around again. Almost to the end, ladies and gentlemen. So, you sat through testimony of three witnesses. I would ask that you find Ms. Robinson not guilty of the crime of malicious destruction of property. I kind of start where I ended earlier with my opening argument. Show me Missouri, right? They had to show that third element that I was talking about, that there was intent there. You heard the testimony of what happened from Mr. Melvin, from Ms. Robinson herself, that he snatched her up into the vehicle, and perhaps in that flailing, perhaps she did, she doesn't, perhaps she did scratch him, perhaps she did kick that door, but she denies any other damage to that vehicle. The complaining witness in this says that his vehicle was in mint condition. Most used vehicles are not in mint condition. He was not able to provide any of that evidence to the court today. Again, the burden of proof here is beyond a reasonable doubt. Have the prosecutors removed all reasonable doubt from your mind today? Have they removed all the reasonable doubt from your mind so that you can say, okay, beyond a reasonable doubt, there's no more reasonable doubt that Ms. Robinson maliciously and intentionally damaged this truck. The reasonable doubt are those photos that we saw of Ms. Robinson, the injuries that she sustained, how she felt. Earlier, she testified that when he was talking to her, it felt like she felt like he was making her be a prostitute. Mr. Melvin talked about how there was just tension in the air. Mr. Greenwood himself said that he was cussing at her. He was talking to her in a manner that was pretty aggressive, in an aggressive manner to her. This all goes to corroborate and back up Ms. Robinson's version of events. Yes, they were out, but you cannot snatch somebody from inside your vehicle and pull them into it. The testimony was that he snatched her and pulled her in, and her legs are dangling. She's flailing, trying to get out. Her testimony earlier about that was that when he first punched her, that first punch was so hard that she felt like she was gonna die. That was her testimony. Mr. Melvin testified that he didn't want anything to do with this. He had heard their talking, so I don't know what they're doing, but then when he realized that she was in trouble by seeing that bloody lip in that photo, that's when he stepped in. He was like, okay, maybe she does need help. At the beginning, he didn't know what was going on, but once he saw that physical injury, he came back and assisted her and took her home. The people talk about how he didn't witness the whole thing. I reconfirmed with him. He said he had seen the whole thing. He was not that far away from the incident. He did not see any additional damage to the vehicle. He witnessed her getting snatched into the vehicle. She did not cause physical damage to that vehicle prior to her being snatched into the vehicle. Mr. Greenwood had to re-clarify some of his statements. The people proposed that he was consistent and he was credible, but he did have to clarify some of his statements. When I asked him, did you throw a drink? No, I didn't throw a drink. Oh, wait, I did throw a drink. All right. And then he goes on to give a full explanation of how he threw the drink, where he bought the drink from, all that. So how he went from not remembering any drink, period, to now throwing the drink, where he got the drink from, how many ounces the drink was, and that he threw it at her. That is inconsistent testimony. Mr. Greenwood was an old boyfriend of Ms. Robinson. They've been on and off. He was a jealous boyfriend. When he had seen her with Mr. Melvin, he kind of lost it. He grabbed her into the window of his vehicle. A Ford F-150, it's a pretty tall truck. It's a pretty tall truck. For you to be able to grab somebody, pull them into your window, that requires a lot of force, a lot of strength, and that just shows how upset he was at seeing her with another person who was just a friend, who was just trying to get her out of the house because of a tragedy that happened in her family. I want you to take all the evidence into consideration. Earlier today, I had asked questions about if damage happened to a vehicle, or you get all this other stuff that shows what happened, would you take that into consideration? And I want you to take that into consideration. I want you to take into consideration that to Mr. Melvin, it appeared that Ms. Hayward demanded that Ms. Robinson go with her. It appeared that he was aggressive. He himself said that he was aggressive. The testimony from both defense witnesses is that he grabbed her without any provocation at all. And that's when the tussle happened. Not only was she injured while in the vehicle, halfway in the vehicle, when they got out, there was another tussle and she got punched in the head and she had the injury on the floor. And then in addition to that, instead of him, Mr. Haywood, if he was in fact the victim, leaving, the testimony is that he slowly follows them down the street, down Michigan a little bit, and then pulls all the way down to Michigan, further down, and stops. And that's when Mr. Melvin says, "Let's get in the car, let's go." And he takes Miss Robinson home. Miss Robinson was defending herself. She was defending her life. Mr. Haywood saw her, was upset, could rage, and all of this happened. You were here. You heard the testimony from Miss Robinson and Mr. Courtroom. So I would ask that this jury, again, the third element, that Miss Robinson did not have any intent, and that the flailing that would have caused damage, she doesn't deny if that side front door had any damage. Perhaps she did that, but it was not intentional and it was not malicious. But any of the other damage she did not do. She vehemently denies that. Mr. Corey Melvin testified that he did not witness any other damage to that truck. So therefore, I ask that you find a verdict of not guilty for malicious destruction of property, so that Ms. Robinson can move forward with this incident, this traumatic incident that occurred to her on November 5th. Thank you.
Okay. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a verdict, true and just, based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instruction about the law. You must take all my instruction together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. It's going to keep doing that.
Okay.
I don't know why it does that. It only does it when we do jury instructions. We've proven that fact. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law, and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. I think the only time I have stricken testimony in this particular case was the testimony stricken in which the victim testified and made a statement regarding the defendant's alleged probation status or a probation officer. That's not evidence. You're not to consider that, okay? Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about November 5th, 2022, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions along with you and your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement, express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff, who's my court officer here. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any of the reference documents or exhibits that have been admitted, you just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking the same example, if you see a person come in from outside wearing a raincoat covered with small raindrops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. I don't believe we had any stipulated facts today. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances that are in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. The defendant is charged with malicious destruction of personal property. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the property belonged to someone else. Second, that the defendant destroyed or damaged that property. Third, that the defendant did this knowing that it was wrong without just cause or excuse and with intent to damage or destroy the property. Fourth, that the extent of the damage was less than $200. The defendant claims that she acted in lawful self-defense of herself. A person has the right to use force to defend herself or another person under certain circumstances. If a person acts in lawful self-defense of themselves or others, their actions are justified and they are not guilty of the crime. You should consider all of the evidence and use the following rules to decide whether the defendant acted in lawful self-defense of herself. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made and the circumstances as she saw them. When you decide whether the force used was that which seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself. But you may also consider how the excitement of the moment affected the choice that the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. And that concludes our jury instructions. You may take your notes and things with you. We do have a copy of my jury instructions in total, and then you are going to be released to deliberate, okay? For you, Mr. Bigelow, please raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise until the time that a verdict has been received? So help you God.
I do.
Thank you. All rise. We are in recess until we get a verdict.
Your Honor.
Oh, we got
Yeah.
too many people, huh?
Yeah.
Can you pick one for me? One of you will get to go home. That'll be juror number 7. Any objection to that? And the reason why I say that is because she's the only Black woman on the jury.
No objection, Your Honor.
Objection, Your Honor. It was
No
random,
objection.
so.
Okay, you may be excused. The rest of you are free to deliberate. Okay, we'll recess until they have a verdict or a question, so don't go far.